And I have severe pulmonary edema. I was bedridden on the day of the recovery as well. I'm not contesting leadership, the recovery itself. I'm very humbly requesting leadership, if possible, interim may be considered your leadership on medical ground. Your leadership?
Page 53.
53, 53, your leadership. 53 is the first report. The second report, the echocardiography leadership is at page 54. And the relevant findings are at page 55. 53 and page 54 and 55. This is 4 days prior to the FIR, your leadership. I was bedridden on that day. At page 53, impression number 2, your leadership, bilateral perihilar opacities. It's called bat wing opacities as well, your leadership. It's an indication of pulmonary edema, or it could be leukemia as well, your leadership. I could not verify that because I was arrested in the meantime. 53, your leadership, page 53, under impression, if your leadership kindly sees point number 2, bilateral perihilar opacities seen likely of infective etiology. This opacities, your leadership, it's either caused by pulmonary edema, that also I've annexed your leadership at page number 56, annexure 10. These opacities, they are either caused by pulmonary edema or pneumonia or leukemia, your leadership. I have not verified, but these are the 3 causes, leading causes. I have a very humble prayer, your leadership, that interim may be considered. FIR is at page 23, your leadership. It starts at 23. The narration is at page 25. The recovery, your leadership, is from my kitchen, from amongst some rice sacks, not from my body, your leadership. Page 25 is the narration, your leadership. It's an FIR dated 18th of March 2026, on which date I was arrested as well.
Sachet has been submitted?
No, your leadership. That's not. And 20B2B, your leadership, up to 10 years.
NDPS ECHO?
I have an extra copy in case your leadership wants.
NDPS ECHO. Pal. It's okay, I have it.
It's intermediate quantity also. Intermediate quantity.
5.9.
5.9.
10 is
20 is
20 is.
okay. Do you have any objection?
I leave it to Lordship, but around 6 kg was recovered. There was a slight difference in the weight.
Yes. In the 52A, they found 6.04 kilos. During recovery, they said 5.98 kilos. There is a difference of 40 grams found in the 52A report. The small quantity is 1 kilo, your leadership. Commercial is 20 kilos. Therefore, this is intermediate.
Registered under which section?
20B2B and section 25 NDPS, your leadership.
Third learned counsel, Mr. A. Gautam for the petitioner Montu Rai, who has filed his application under section 483 of the BNWS 2023 with prayer for bail, as he is behind bars since
18/3/2026.
Eighteen 2026 in connection with so-and-so PS case, GR case under so-and-so sections. Had Mr. B. Sharma, learned additional PP Assam, who stopped. The petitioner has prayed for bail as he is suffering from, what is the ailment?
Cardiomegaly and pulmonary edema, Your Lordship.
Which page?
Page 53, please. Annexure 9 at page 53.
Cardiomegaly, CARDIOMEGALY, and where else? Pulmonary.
That is, Your Ladyship, at Annexure 10, page 56. That is the reason the differential diagnosis for the opacities is there, Your Ladyship. Bullet point number 1 under differential diagnosis.
And pulmonary edema, PULMONAR, pulmonary edema or cardio, CARDIOMEGALY. Annexure 9 and Annexure 10, along with the petition, which are submitted along with the petition are the, what is this? Reports.
Annexure 9 is the reports, Your Ladyship. Annexure 10, it's the meaning of the term opacities, Your Ladyship.
Are the reports and medical documents relating to the petitioner's ailment. Full stop. It is further submitted that the petitioner will cooperate with the remaining part of the investigation. Full stop. The learned additional PP has raised objection against the bail petition. Full stop. I have considered the submissions at the bar with circumspection. I have also considered the length of detention undergone by the petitioner. Full stop. I have considered the submission that the petitioner is suffering from heart ailment. Full stop. The petitioner has pledged to cooperate with the investigation, and he does not appear to be of flight risk. Considering all aspects, the petitioner is enlarged on bail of rupees 50,000 with a suitable surety of like amount to the satisfaction of the learned. Which court?
This will be the learned CJM in Morigaon, Your Ladyship. CJM, additional CJM in Morigaon.
Additional CJM Morigaon. Learned CJM Morigaon, under the condition that the petitioner shall cooperate with the remaining part of the investigation. Number 2, the petitioner shall not leave the jurisdiction of the court without prior permission. And number 3, the petitioner shall refrain from such activities with which is alleged. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner.
I apologize, Your Ladyship. Perhaps it will be special judge because the remands are being done by the special judge there, Your Ladyship.
Jurisdictional court, a stroke duple elaka magistrate.
Great. I'm deeply obliged.
Item 46, supplementary list. Met legal. Lordship, the FIR at page 13, Lordship, allegation of recovering 3 kg of suspected B plus.
Page number 13.
13.
The petitioner, the allegation against the petitioner is that he was that 5.900 kg of ganja was recovered from his house. First page. Yes.
Page 13, Lordship, in the FIR.
1313.
Lordship,
13.
13, Lordship.
Okay. Please read the FIR.
With due respect, I would like to report that on 18/4/2026, at about 10:30 a.m., information was received that the local villagers of number 2 Matiapara village had apprehended a person in possession of suspected beef. The said information was duly recorded in the general diary.
You are behind bars or this is anticipated?
18/4, Lordship.
Huh?
18/4, I am arrested.
You have any objection?
Also let the CD come next week, 18/4,
18/4.
Lordship. I'll leave it to Lordship.
2 weeks, I think. Today's 2 weeks.
Lordship.
Today is 29.
18,
You want a CD?
Next week, we get.
Okay. CD
Lordship,
then.
then I am suffering because I have 2 young child, Lordship. Old age parents, they are suffering. Lordship.
Next week, if it doesn't come, Lordship will consider.
Lordship, in the
Short
meantime, I may be allowed to go on interim bail, Lordship.
Interim bill, why? You are suffering from any ailment?
Lordship, no, I am not, because my children, Lordship, young children, 2
You are a
minor
laborer.
girl, Lordship.
Laborer.
Lordship,
You are a laborer.
Lordship,
Where?
Lordship, we have, actually, he is a cultivator, Lordship.
Which paragraph?
Lordship, para 2, Lordship. Page 3, Lordship.
Okay then. Let him go. Let him go.
Lordship will dispose it of course.
2 young children.
R. Islam, Lordship.
Heard learned counsel Mr. R. Islam for the petitioner. Asad Mia, alias Asad Mia, who has filed his application under section 483 of the BNWS 2023 as is behind bars since 18/4/2026 in connection with so-and-so PS case under so-and-so section GR number 2. Had Mr. B. Soma learned additional PP Assam, who stopped. The allegation against the petitioner is that he has been apprehended with illegal possession of 3 kgs of beef, BWF, full stop. It is submitted on behalf of the petitioner that he is a cultivator and his 2 young children are suffering as is behind bars, full stop. The petitioner has pledged to abide by any bail conditions if imposed upon him, and he has pledged to cooperate with the remaining part of the investigation. I have considered the submissions of the bar with circumspection. I have considered the submission that the petitioner is a cultivator who stopped. The submission of the petitioner that he is willing to abide by any stringent bail conditions if imposed upon him is also taken into consideration. Full stop. The petitioner is a local resident and is not a flight risk. Considering all aspects, the petitioner is enlarged on bail of ₹30,000 with a suitable security applied amount to the satisfaction of the learned Elaka magistrate from jurisdictional court under the condition that the petitioner shall 1 refrain from such activities with which is alleged. Number 2, the petitioner shall appear before the IO on every fortnight till completion of investigation, and the petitioner shall not refrain from such activity and shall not leave the jurisdiction of the court without prior permission. On breach of any of the bail conditions, the court is at liberty to immediately cancel the bail granted to the petitioner.
Obliged.
Okay.
Identified.
May it please the Lordship. Lordship, this is a pre-arrest bail application. Lordship, the translated copy of the FIR is at page 11. May I read it, Lordship?
One
1031 and 35 of PM.
we'll need the CD.
CD will be required.
103.
Lordship.
No point going to the FIR. Call for a CD, list the matter. It's under investigation or it's subject to submitted.
Investigation is going on.
Call for the CD, list the matter on date of minimum 2 weeks will need.
Close.
Obliged.
Item 47, supplementary list.
POCSO is
Lordship.
there, Lordship. Notice may be
Sir,
issued.
kindly pass over the matter for time being, my lord.
POCSO is there, Lordship. Notice may be issued.
Why time being? Will issue notice, bail application in POSCO. Charge has been submitted?
No, under
No,
investigation.
okay, learned counsel, Mr.
A Khalek.
A. Khalek is present for the petitioner. Full stop. Steps to be taken by the petitioner to issue notice to respondent number 3. Full stop. The learned additional PP, Mr. B. Sharma has accepted notice on behalf of respondent number 1 and thus no formal notice is required to be issued. Please, on data deduction, short date.
Short date.
For return of notice, for report on notice and call for the
CDO.
and for CD. Call for the CD to mother likhi diba de. Okay.
Obliged.
For motion, item 4.
May I please, Your Lordship? In this case, my lord, petitioner has been convicted under NI Act, my lord. 138 of NI Act, the operative part, my lord, page number 27.
You have submitted the corrected cost letter.
Lordship,
You want a stay?
no one.
Acquitted? Acquittal order?
For motion today, my lord.
Oh, you, on motion, yes.
Okay. I'm for praying for interim, my lord.
That is why I'm asking. You want a stay?
Lordship,
Then you'll have to deposit 20% of the compensation. You'll deposit? Where? Huh?
no. I'm not depositing. We'll deposit, my lord.
20% of the
Lordship.
compensation amount?
Lordship,
Okay, then we'll stay.
Lordship.
Learned counsel, Mr. R. Ali.
H.A. Ahmed.
H. A. Ahmed is present for the petitioner. You have added the state as respondent?
No one.
No.
Independent, private testimony.
For the petitioner, Intaj Ali Chaudhary, who has filed this application under section 438/442 railway section. Why you are adding 528? Not required.
For stay there for
You should have left this 528 for some later relief.
praying for stay in this petition, my lord. No separate.
Okay, 528 of the BNWS 2023, as the petitioner is agreed by the judgment and order dated 5/3/2000. Okay, not 5/3/2000. 7/11/2023 in connection with NI case number 62 of 2022, sentence convicting the petitioner under section 138 of the NI Act and sentencing him.
Page number 27, my lord.
To pay a compensation of rupees 6,000 to the
6 lakh.
complainant, Mustafa Ali.
6 lakh.
Oh, 6 lakh. 6 lakhs to the complainant, Mustafa Ali. The petitioner is also agreed by the judgment and order dated 5/3/2026 passed by the learned. To full stop the passed by the learned Sessions Judge Bozali Patsala in connection with criminal appeal number 18 of 2023, upholding the judgment and order passed by the learned Chief Judicial Magistrate. Agora Chief Judicial Magistrate लिखना नहीं. Convicting. Chief Judicial Magistrate लिख दीजिए. Upholding the judgment and order of the Chief Judicial Magistrate, convicting the petitioner in connection with NI case number 62 of 2022, full stop. Where is the player?
Yeah, page number 8 and 9.
The petitioner has prayed for suspending the operation of the impugned judgment and order dated 7/11/2023 and to remain on previous bail, full stop. It is submitted that the decision rendered by the trial court as well as by the appellate court is an decisions are erroneous decisions, and the petitioner has a strong case. Full stop. I've considered the submissions on behalf of the petitioner. Full stop. The operation of the impugned judgment and order dated 7/11/2023 passed by the learned CJM Bozali Patsala in NI case number 62 of 2022 is stayed until further orders, subject to the condition that the petitioner deposits 20% of the compensation stroke fine amount in the trial court.
In the trial.
In the trial court system. Call for the records of NI case number 62 of 2022 and criminal appeal number 18 of 2023 from the respective courts. Issue notice to the respondent returnable within 4 weeks. List accordingly.
Obligation.
Item 5.
Let me tell us. My prayer before your lordship, my vehicles were seized in the connected case. So, my lord, I make a prayer for Zimma. Zimma was allowed. But only problem is this, bank guarantee of ₹5 lakhs is to be given for each vehicle. Your lordship will turn to page 45.
Okay.
I am agreed by this portion of the order. My humble submission before your lordship, I have purchased the vehicle in April only, and it was seized also in April. And I have taken the vehicle, we have taken the vehicles on loan, my lord, about 10 lakh, 8 lakhs, and EMI is to be paid. So, my lord, we are poor person at the time of purchase, my lord.
Okay. All right. I understand. Yes.
Only indemnity bond, my lord.
What do you have to say?
Okay, in the act itself, there is a provision for releasing the vehicle under bank guarantee. So there is nothing wrong with the order. They will have to show lordship if
In
something.
the act, yes.
Yeah, in the
There's a
act,
problem. It's the provision in the act is this bank guarantee is mandatory, I believe. Let me see the act.
cattle preserve, cattle preserve. Bank guarantee after consent jama.
Which section?
I think 11 lordship, 11(5). 11 subsection 5. Cattle Preservation Act 21.
Yes, mandatory.
My lord,
You have any
lord,
order of this court?
possibly it is not mandatory, my lord. May.
No possibility.
My lord,
I cannot.
my lord,
don't
your
possibility.
lordship, if the word is shall, then it will be different, my lord. Anyhow, my lord, let me examine. I have not come with the book. It may come, my lord, on another day.
Another date.
Yes, my lord. Let me examine.
Mr. M.A. Sheikh has prayed for adjournment. List this matter on 21.
My lord, on Friday, my lord.
This Friday.
Yes, my
Friday is
lord.
closed.
Some urgency is there, my lord. My vehicle holiday.
Monday or Tuesday?
Monday, my lord.
Not Monday, maybe Tuesday.
Tuesday.
Tuesday পারিনি বহুত কেস আছে ন হিয়ারিং এর কারণে
Maybe on Wednesday, my lord. No.
Wednesday, yes.
Wednesday.
6-5.
Obligation.
Item 6.
Nothing much.
Yes.
Quashing of a my lord complaint case registered under my lord the FIR mail. And I just take your lordship to page 153, 150, this 154, my lord. Hey, my lord, find this, my lord, just because first I think because the question of voice involved, my lord. That's why I come. CF this, my lord.
154-3.
Yes. 154, 3, my lord.
I think I know.
Yes, certainly, my lord. More than myself, I am not so much thorough, my lord.
It always appears new. Every time, whenever we read it, open the book, open the
Yes.
section,
But even we read by the 438 also sometimes we read.
sometimes it appears very new. Always, not
Ah.
sometimes, always. Some new thing crops up.
Now,
154-3.
see, any person agreed by a refusal on the part of an officer in charge of a police station to record so and so, send the substance of such information in writing by post or so and so, so and so. So my case is the one on this point. Here, initially took FIR as lost. They are the accused persons, my lord. This present informant is the complainant is the accused in 2 FIR pending 2020. Now this case was filed without complying, my lord, 154(1) and 2, my lord. This FIR, my lord. Now I take your lordships to first. I take your lordships to page 20, page 18, my lord, page 18. FIR, first FIR. Page 14. English, your lordship, my lord. This is dated, my lord.
Page 14.
Page 14, English version, my lord. 18 is the vernacular. FIR. Your lordship. Page 14.
First FIR.
Yeah, first FIR. It is lodged by petition number 16. By petition number 16. Regia Begum. Petition number 16. Your lordship got it. 16. Now, the complainant's name is page 14, number 2, my accused. Your lordship. Got me, man. Moniruddin. He is the complainant in complaint case here, case, man.
Okay.
So this was registered at 326 along with others, my lord. Then come through, my lord, second FIR, page 20.
Okay.
Page 20. Your lordship will find their informant is Rumi Begum. Petition number 6. And informant is the complainant is number 1, accused number 1.
And Rumi Begum is here, petition
Petition
number.
number 6. This was also registered 326, 307, 392, etc. Again, that complaining.
Okay.
Now you'll also kindly come to page 26.
Yes, page 26.
Page 26. This here
Here is
case.
the complainant and the present case.
That, yes, present case where I am.
This complaint case.
Yes.
State is a party?
State is a party. And here your lordship, Maniruddin is the complainant minor. That accused number 1 and accused number 2 in both the cases. And date your lordship kindly see, this was filed on 23/9, top right side minor, corner. 23/9/22.
Okay.
Filed by Maniruddin. That
So these
accused.
two cases were all registered, but
I know?
earlier cases were registered.
Yes, yes, yes. Case number, your, yes, registered matter under section, I have given the section matter.
Hmm.
Number first FIR is registered under Udarban PS case number 8420.
Both, yeah.
Yeah, both registered. Both registered going on, madam. Going on.
Cases are proceeding.
Yes, this is going on. Now, this same person has now after 2 years, madam, he filed the present FIR without complying 154 AB, my lord, and that is my case, my lord. So whether it goes on, one judgment by the just your lordship of Priyanka Srivastava is there, and latest one is the only simple points, the law point here, madam.
You're asking for interim stay.
Yes, for further proceeding, madam. It cannot go, my lord, because of this judgment. Kindly paragraph 7, my lord, of this judgment. Because here Priyanka Srivastava was mentioned, and for quoting the original case is my lord Priyanka Srivastava, but your lordship can say paragraph. Paragraph 6, your lordship started the provision. Paragraph 5 and 6. Yes. Paragraph 5, my lord, your lordship kind of first paragraph 5.
5 and 6. Okay.
Yes. 5, your lordship with Priyanka Srivastava 30, 31. Now 31, your lordship. We have already indicated your lordship.
Hmm.
Paragraph 31. It was quoted, my lord, in 31. We have already indicated that there has to be prior application under section 154(1), 154(3) while filing a petition under section 156(3). Your lordship, whatever. Both the aspects should be clearly spelled out in the application, and necessary documents to that effect shall be filed. The warrant for giving a direction that an application under section 156(3) be supported by an affidavit is so that the person making the application should be conscious and also endeavor to see that no false affidavit is made. It is because once an affidavit is found to be false, he will be liable for prosecution. Affidavit means by the, along with the complaint that affidavit is given, giving all these things, I have gone to the police refused it, then I go to higher authority, refused, then I come before. This is not there at all. This is the case. And paragraph 8, my lord. Subsection, this is also important. Paragraph 8. Your lordship.
Yes.
Subsection 1 and 3 of section 154 are the two remedies available for setting the criminal law in motion. Therefore, this court held that before a complainant chooses to adopt a remedy under section 156(3), as in present case, he must exhaust his remedies under subsection 1 and 3 of section 154 CRPC, and he must make those amendments in the complaint and produce the documents in support. However, in this case, the second respondent did not exhaust magistrate, and the High Court have completely ignored the binding decision of this court in the case of Priyanka Srivastava. I think your lordship got the point, madam.
Yes, PP. Can we grant stay?
Yes, it is a case, madam. It cannot proceed, madam.
There is a procedure prescribed,
Yes.
as per the Supreme Court also, lordship.
Third learner senior counsel, Mr. H.R.A. Chaudhary, for the petitioners who are aggrieved by the petitioner Hullota আছে দেই কোনো হুল্লো নহয় বেশি আছে 20 petitioners who are aggrieved by the who have filed this application under section 528 of the BNWS 2023 with prayer for crossing the proceeding arising of the complaint dated 23/9/2022 registered as CR case number 243 of 2022. It is submitted on behalf of the complainant. It is submitted on behalf of the petitioners that the complainant has been facing trial in connection with
In connection with Udarbon PS case number.
in connection with
No.
Udarbon PS case number
8420 and
84 2020 and
Udarbon PS case number, what was it? Second term,
148.
14820.
Udarbon PS case number
Two case. One is file number one is page, your lordship, one page
58 and
84 and 148.
Now, after 2 years, the complainant has brought up a false complaint case against the present petitioners. Full stop. The complaint has been supported by an affidavit.
Page 26, madam. The affidavit is page 32.
Which clearly reveals that he had earlier submitted an FIR before the police station, which was not received by the police.
Yes.
Full stop. It is submitted that if the FIR is not received by the police, the complainant has to inform the superintendent of police regarding the non-acceptance of the FIR as mandated by section 154(3) of the CRPC of the Code of Criminal Procedure, within brackets CRPC for short, which reads 154(3) লিখি দিব হা ಇದು CRPC ಅಂತ ಉಳಿಯಲು লিখি দিব
The magistrate taken cognizance matter, that is our case. Page 39.
It is submitted that the affidavit does not disclose that the complainant had approached the superintendent of police. With his grievances against the officer in charge who refused to accept the FIR submitted by the complainant, who is arrayed as respondent number 2 in this case. You have annexed the
Cognizance order is page 39. I should take a cognizance thereafter that. That is to be understood.
no statement under section 202. 200, okay,
Oh,
here it is.
Yes, that we have not, no? 22 and so. Yes, it is there, man. Yes, page 33, man. Police also accused murder in this case. They already came before this honorable court and This number, proceed, and then answer. What? Not to the trauma player on it. Okay. The happy little conspiracy.
the statement of the complainant, Muhammad Moniruddin Bhuya is annexed, is
That's a deal.
marked as Annexure D of the petition. See, will this vitiate proceeding?
Yes.
If the statement under section 200 is not recorded, will it vitiate proceeding? Oh, no, if it is not sent to the police station, to the SP?
No, 2002 will not, here also, madam, they have to say in the affidavit itself, madam, in the complaint itself, madam, that they have gone to the OC, police also might have here accused, madam. So,
Paragraph 9.
paragraph 9 of the, my lord, judgment. Your lordship can read paragraph 9 of the
Yes.
judgment.
Let us again.
Set aside and question.
All the further steps taken in the decision.
Copy must. No, no, leave over. What was that? I don't know. It will Srivastava, let them mention this. Main case to Srivastava. Yanka Srivastava. Also, I got to go.
Other judgments come also, they later on also, that because of that non-compliance of the section 153, the case is not goes.
Vitiated.
Vitiated. This is a curable defect that is also there.
How it can be curable, my lord? They should know something about how it will be curable, man. Already filed without adjusting.
I am not saying this is the judgment.
No, I am saying, please, I am just saying, it cannot be curable, already filed the criminal case, man. It cannot be curable, man. Either it will go or they may file a fresh complaint. That will be fine. But it cannot be cured, man. The lapses which they made. Conclusive. Lock up. And conclusive. Latest.
March 6, 2024.
This is decided on March 6, 25.
It will not vitiate proceeding. 461.
460.
460.
CRPC.
To take cognizance of an offense under clause A or B of subsection 1 of section 190.
Cognizance will be taken once it is maintainable, my lord.
It will not vitiate proceeding.
No complaint. 460. Not being empowered by law in this behalf does any of the following things, namely, it has issues, charge, demands.
Priyanka Srivastava case I have read.
Yes, this is mentioned here. We are having also that,
The court is to be shy while taking up complaint cases.
but this is the latest one, madam. This one. Only March 25, madam.
No, but when two benches differ.
But Supreme Court, madam, because they referring Priyanka gave us up, this is what I was given. Paragraph 9 can say, madam. Paragraph 9. Referring that Priyanka is abstained. Subsequent order, madam. We are having Srivastava judgment also, my lord. But here you are referring this one, this is March 25.
Please give me Priyanka Srivastava's judgment. I'll pass an order later.
Right.
Because you see, already there are two criminal cases booked against him. And he's,
So
the
one thing can you, my lord?
police is not favoring him at all.
No, my lord. If your lordship pass some reason order, then notice may be issued, my lord. In the meantime, you will fix it because the law is to be settled, my. I think your lordship, that can be done, my.
What?
Your lordship will dispose it today or it will, my lord. Your lordship will issue notice.
You are asking for interim order only?
Yes, interim,
I'll issue notice.
my lord. So interim order also, my lord, unless there is no,
That is why, whether I'll pass an interim order or not, I will go to
Order.
both his judgments and then I'll pass. And if, in case if I do not pass an interim order, maybe I will not write down all this. And if I pass an interim order, then I'll write down whatever has been dictated.
but this is the latest or my March 25.
I'll read both the
Right.
judgments. Priyanka Srivastava, I have read.
And if you get latest anything, my lord, we will also submit my lord, he will give my lord. If there is latest judgment, as my learned friend has said, man, if there is anything, my lord. Because here your lord, paragraph 9 of the later judgment, the quashit, my lord, set aside.
I know.
Your worship.
It has been-
So this is the law now, as of now. Priyanka Srivastava has gone, but this is the latest.
Okay.
Obliged to law.
In case I do not pass any interim order, I'll only issue notice. In case, then I won't write all this.
That's right.
But-
It was a returnable short date, my lord.
Yes.
But I hope your lordship will pass, my.
Let's see.
Your my lord.
I'll try. I'm always
Hello.
trying to give some relief to the parties. If I cannot, then and see, I have to think for the
But
other
on the
side.
face of it, your lordship say, my lord, 2 FIRs.
I have to think for the other side also. He's been incarcerated.
My
in
lord, let them
cases.
come and let them say their own, whatever they
And
say, my lord.
how will they come and say when we stay the order?
No,
how
no,
will they
stay the
come?
order means 2 years already, heaven will not fall, my lord. If 2 weeks time is given and your lordship stay, my lord.
No.
They'll come immediately because their
You
interest
see,
also is
they
there.
have been incarcerated also in several cases. I'll have to think
Oh,
for both the sides,
Always,
not only for one side.
always.
Let me don't think about more silent.
Item 7.
Six picture দি দিব হা নামটো লিখি মেলি দি দিবা কোন কোন কাৰ কাৰণে এপিয়াৰ হৈছে
Object, this is petition for crossing of an order dated 19/1/26 and also the whole proceeding, lordship. Because lordship, what happened in this case, lordship, this particular criminal case was filed against me for the custody of the minor children, lordship. But that custody is already given to the wife. Lordship, may kindly see the order dated page 15, lordship, 15.
page 15
15, 15, lordship. Alexa 1. May I read the order? Case record is taken up in my file. Peruse the petition along with the affidavit filed by one Srimati Khairun Nessa, wife of Sri Zakir Hussain, daughter of Sri Abdul Latif, resident of so and so. Hard running advocate for the first party at length. It is stated by the first party that she was married to the second party in accordance with Islamic rights and rituals about 11-12 years back, and out of their wedlock, 3 children were born, namely Magdiz Alam, presently aged about 9 years. 9 months. Sumia Begum, presently aged about 6 years, 2 months, and Mehboob Alam, presently aged about 5 years. It is alleged that since after the marriage, the first party has been tortured by the second party, both mentally and physically, on demand of dowry, etc. It is also alleged that 1/11/24, the second party abandoned the first party and left the house along with their minor children. It is further alleged that the second party married another woman and is presently staying along with his second wife and the 3 minor children at the address mentioned above. The first party, being the mother, is now worried about their minor children and alleges that her minor children are ill-fed, ill-treated, and deprived of basic necessity of life. The first party further alleges that the second party has wrongfully confined her minor children and whose lives are insecure.
The first party therefore prays for recovery of her minor children from the house of the second party and other probable places. From the above, I am of the opinion that the activity of second party is an offence and attracts provision of section 100 BNSS, previously 97 CRPC. As such, I am satisfied to draw up a proceeding under section 100 BNSS and direct OC of the concerned police station to search the house of the second party and other probable places for recovery. Magdi Alam presently aged about 9 years, 9 months. Sumia Begum presently aged about 6 years, 2 months. Mehboob Alam presently aged about 5 years and recovery gives Zimma of the minor children to the first party petitioner who is also the mother of the children with an information to this court on observing all formalities on or before the date fixed. Issue search warrant accordingly inform all concerned dated fixed 2/26. That is the case lordship. And thereafter I given the custody on 21/26 lordship at page 9 paragraph 11 lordship. That date was wrongly typed lordship. Actually 21/26 I given the custody of the minor children.
15 is the proceeding and thereafter custody was given.
Custody during the pendency of that proceeding lordship, custody was given lordship.
Page 9.
Page 9 paragraph 11. 21/26 lordship. Paragraph 11. Lordship. The petitioner begged to state that a case filed by the respondent number 2 is now become infructuous as because custody of minor children has already been handed over to respondent number 2 on 21/26. As such, the petitioner is hereby preferred this petition for quashing the entire criminal proceeding of case 30/26 pending in the court of Dr. Borua, additional magistrate, Kasar Silchar on the following grounds among the same. That is the case, lordship. In fact, lordship, the petitioner also filed a complaint case against this lordship, respondent number 2, his first wife. That is at page lordship, page 24, lordship. In fact, lordship, the allegation against me is lordship, I am torturing. Lordship.
Will issue notice.
Tell me, lordship, proceeding may be state lordship.
Huh?
Proceeding may be state lordship.
No.
Because custody was already handed over to the lordship.
Yeah, I believe you, but even then let's issue notice. What is the point of staying the proceeding? Custody has been handed over. What is the point of
Search warrant
staying the
was issued.
proceeding?
Search warrant was issued, lordship. That is why lordship are insisting for the stay, lordship.
Search warrant has been issued.
Lordship, against me for custody of that minor lord because
When is the order then?
Lordship, I read out lordship at page 15.
No, but order of handing over the children.
No, order is not there, lordship. Order is not there. But actually custody was given, lordship. In fact, I was lordship informed by the council of the trial court, lordship, that there is case is already.
We will close it. No point. Let us. No problem.
Notice.
Search warrant is issued.
Lordship.
Cannot stay actually in this manner. Because when you are in the petition, you are claiming that the children are being handed over.
Handed over.
If you grant stay.
Then lordship, because lordship, this case is pending still now. After custody of
When is the next date fixed for search?
Next date, lordship. Next date 2/26, lordship. 2/2 of February 26. Date has already been gone, but still case is pending. That is the case, lordship.
No, but
case is pending.
this order does not appear to be justified when the children are handed over. Then why should I stay?
Because
The proceeding.
This proceeding was
We'll
under
quash it altogether.
lordship,
After hearing the other side.
small submission, lordship.
Yes.
Because 100 BNSS, that is a custody for the custody of the minor children. Custody was given. In fact, this petition itself become infructuous. That is why lordship saying that lordship may issue notice and lordship state a proceeding and fix a short date, lordship. Everything will be clear, lordship.
What do you have to say? Let me ask the government. Let me ask the government.
Lordship, notice maybe issued at this stage, let them appear and then lordship can finally dispose it of.
We'll dispose it.
Yes.
Let them appear when she has gotten the custody of her children. She will not raise any objection. Only she is worried about the custody of her children.
Lordship.
And this is not a proper proceeding to take guardianship of her children. Proper proceeding will go to family court.
That is
Not family court, maybe district court.
district court. Let's short that one picture.
Very short date.
That's it.
Because when the children are handed over, then if I stay the proceeding also, it will be appear very unjustified also. There's no litigation, only when there's no litigation, why to stay the litigation? There's no litigation, nobody will go and appear there.
Lots of that.
Had learned counsel Mr.
Yes, sir.
A. Sharma for the petitioner, who is aggrieved by the proceeding under section, proceeding being miscase or what case number?
30 of 20.
Miscase, no?
30 of 20.
Case number, case
Yes,
number
case
30 of 2016,
26.
26, pending in the court of the additional district magistrate,
Kacha Silchar.
Kachar Silchar, full stop. Issue notice to the respondent number 2, returnable within 4 weeks, full stop.
Can it be 3 weeks, lots of?
Returnable within 2 weeks.
2 weeks.
3 weeks.
2 weeks.
It will not come in 2 weeks.
3 weeks. 3 weeks.
3 weeks.
3 weeks.
Learner addition PP Mr. B. Sharma is present for the state of Assam. List this matter after 3 weeks.
They
do not
otherwise
record
it will be
also.
listed lottery.
Huh?
We'll take steps as possible as early. Otherwise it will be listed lottery. Problem is there. If lottery does not fix any date, then matter will not be listed lottery.
Okay, we'll fix a date.
Any date.
List this
Any date
matter
after 2 weeks.
returnable,
25.
returnable on 25 litigation.
Obliged lottery.
Yes, my lord.
Mhm.
This is for quashing of the section 376 PC one. It's from taking cognizance.
John petition.
Yes, my lord.
John petition.
No, my lord. John.
376.
376, in the taking cognizance of section 376 by the tribe.
We'll have to
owner,
issue notice.
you honor.
It's a serious offense. We'll have to issue notice.
Hmm.
Learner counsel, Mr.
Why sick there? Then that's can you first you will leave? Oh, once does page number 41 is can be one.
No.
Of
Must be issued.
course.
Learning counsel, Mr. Y. Sigda is present for the petitioner. Issue notice to the respondent number 2, returnable within you want a date.
Any problem?
Sorry, Nalbari, at least 3 weeks.
No, don't mind the Kamrup.
Kamru.
Kamrup Metro. You.
Respondent number 2, daughter of Dindal.
Oh, sorry. Respondent number is.
Ah.
Not correct.
Returnable within, returnable 3 weeks or later, did you?
Yeah.
26.
26.
Meanwhile, call for the scan copies of the child court records along with the scan copies of the CDR, CD. Full stop. The learner additional PP, Mr. B. Someone has accepted notice on behalf of the respondent number 1. Thus, no formal notice is required to be issued. The petitioner is not a service holder employee.
No, man.
Then no urgency.
Bless.
May I please, Your
Oh.
Lordship? And the petitioner challenges the order dated
Right.
NI, yes.
Repeat.
No, NI proceeding
Or against the proceeding.
against that order, against the NBW has issued against me,
Okay.
against the petitioner. By the order dated 2/4/2026, page 37.
Have you any of the orders
Oh,
of
yes, all orders.
other orders?
Yes.
So let's start with the orders then. Whether we can keep the MVWA in abeyance.
NBW,
If you're willing to appear and cooperate with the
yes,
trial.
cooperate with me.
So we'll start from the orders.
Impugnated is page 37, Your Lordship. Page 37. Complaint namely is that is in evidence days. I could not able to appear before this learned court below as I could not able to contact my counsel. So NBW issued against me.
This first order is 3/5/2025.
Yes,
The next date was fixed on 5/6.
Yes.
But again, there's an order on 35/2025. Same case, NI case 6 of 2025.
Yes.
CR was put up.
Yes, you have put up. The cognizance has already been taken by order dated 28/11/2005. Page 27. Well, excuse me. We'll come to page 27. Operative part 29, page 29. The petitioner has been facing the NI case regularly, but on that day, then kindly come to page 36. Because the order date 16/2026. The case was picked for evidence on 2/4/2026. Page 36. Page 37 and 38. 38. The learned could below issue face NPWA.
Here, you appear. You can appear. Our learned counsel, Mr.
Arbora.
Arbora. For the petitioner Utpal Thakuria, Utpal Talukdar, who is facing trial in connection with what is the case number?
NI case number 6 of 25.
2025. It is submitted that by the order dated 29/1/2026, bail-able warrant was issued.
2/4/26.
Seen the these are annexure what series orders?
Last order 2/4/26.
Seen the annexure 2 series. Full stop. The order dated 29/1/2026 clearly reflects the first order for issuance of bailable warrant against the petition. Full stop. Thereafter, the petitioner appeared before the trial court on 5/3/2026 and the bailable warrant was recalled on 11/3/2026. The petitioner was absent without steps and On 11/3/2026, no. Petitioner was absent without steps, no. On 2/4/2026, the petitioner was absent without steps and an order was passed by the Judicial Magistrate First Class Tihu issuing bailable warrant NBWA against the petitioner. Full stop. Had Mr. B. Sharma, Lara Additional PP for respondent number for the respondent state, I have considered the submissions that the petitioner is willing to cooperate with the trial. Full stop. The petitioner has defaulted appearance only on 23/4/2026. Full stop. This court has taken a pragmatic view. Thereby, the NBWA issued against the petitioner is kept in abeyance for 15 days. Within 15 days, the petitioner is directed to appear before the learned trial court and cooperate with the trial. In terms of the above observation, this petition stands disposed of.
Item 11.
May I please? Lots of FIR is at page number 22. Relevant is at page number 25. Under section 85, your lordship.
Page 80, FIR is at page?
Page number 25, your lordship.
You want an interim stay?
Yes, your lordship.
Under section 85?
Yes, your lordship. Because 82 has been dropped by the investigating officers, your lordship.
'85-'82.
Yes, your lordship.
Charge sheet submitted?
Your lordship, charge sheet, your lordship, in the High Court, it has been submitted, the final report has been submitted. But ultimately, they have submitted the charge sheet. That is also recorded in the order, your lordship, page number 37. Para 5, your lordship. Previously, I have filed one bail application, anticipatory bail application.
This petitioner is, how the petitioner is related to her
Yes, your lordship.
mother-in-law? How the petitioner is related to the complainant?
Complainant is claiming to be the wife of the accused person, your lordship.
Petitioner is a woman.
Yes, your lordship.
GRPS number 6602 of 2024.
Yes, your lordship.
At this stage, lordship may only issue notice at this stage. Since the matter is charge sheeted and there is a victim informant, lordship, let her appear, lordship.
Well, lordship,
And
kindly
record-
produce the FIR first. Because if there is any cruelty or anything else is being come out from that.
Please read the FIR.
Yes. Page number 25.
Ready?
May I? Yes, sir. This is to inform your owner that on 3 November 2024, through Sri Prasenjit Karmakar, mobile number so-and-so, had trainer in the Hammer Strength Gym, Lal Ganesh Kahlipada, and I have legally married Sri Diptesh Biswas on 28 August 2024, marriage certificate enclosed. Me and my mother-in-law, Mrs. Rani Sangma Biswas, were informed by him that on 23rd of September 2024, they went to Bangalore along with Sri Ananya Podar, which in the knowledge of the father Sri Apurva Podar and his mother, namely not known, residence of house number 29, Bhaskar Nagar, VIP Suites, Kahilipada, photo enclosed that was received from the mobile of Sri Prasenjit Karmakar. My husband Diptesh Biswas come back from Bangalore on 26th of September 2024, late night from next day. I could sense something wrong as because he was avoiding me and my family during Durga Puja. They have gone by air to Puri and then they gone to Bangalore and staying together till date. And the call record of Apurva Poddar, Ananya Poddar and other will prove it.
Where is the charge sheet?
Yes, sir. Charge sheet has it page number 30 as
27, 27.
28, 27 started. And finding is from page number 31, para 16. May I read your?
Yes.
The brief of the case for the prosecution is that on 7/11/2024, the complainant Miss Darshana Kanu, wife of Diptesh Biswas, lodged a written FIR at AWPS alleging that on 28/8/2024 she got married to the FIR named accused Diptesh Biswas after a long courtship since 2011, and after court marriage she used to live in the house of the accused as husband and wife. Now their social marriage was supposed to be held on March 2025. And but on 7th of October 2024, the FIR accused fled away to Bangalore via Jagannath Puri with his girlfriend Ananya Poddar. Hence, the case is being registered and investigated into. In the course of the statement of complainant and witness were examined, IO visited PO and drew up the rough sketch map of the PO, and FIR named accused Diptesh Biswas arrived at the PS accompanying with the notice 35(3) BNSS. Accordingly, he was released from the PS after recording his statement. During the investigation, it was found that the complainant Darshana Kanu and Diptesh Biswas was in love since 2011. In 2019, the complainant caught FIR named accused cheating her with his business partner Ananya Poddar. Therefore, she stepped back from the relationship. Again in 2023, the FIR named accused started contacting with the complainant and through message and calls and proposed to marry her. Accordingly, they got married on 28/8/2024. It is also found that on 23rd of September 2024, the FIR named accused, along with his girlfriend Ananya Poddar, with his friend Prasenjit Karmakar, visited the temple of Tirupampuram, Bangalore, without knowledge of the complainant. And on 7th of October, the FIR named accused, along with the Ananya Poddar, fled away to Bangalore, Jagannath Puri. In the course of investigation, prima facie case is found well established against the defendants.
Two things, Lordship. First, Lordship, it is registered under 85 and 82. So 82 is Lordship marrying again during lifetime of husband or wife. And 85 is Lordship is already seen. It relates to cruelty. Now she is claiming that she is the legally married wife. And Lordship, charge sheet was submitted in the year 2024. So present status, Lordship, at what stage the case is, Lordship, it is not before your Lordship. So I am praying, Lordship, that notice may be issued and the records may be called for. Because prima facie, Lordship, it doesn't appear to be a case of quashing, Lordship. Because the informant is claiming she is the wife, and being the wife, Lordship, he fled away from here and subsequently married to another girl. So, Lordship, all these two sections are attracted.
Your Lordship, subsequently marriage charge has been dropped. And as far as
In
the
section 85.
and
Cruelty.
cruelty does not come out from the charge.
But indulging in cheating and extramarital affair is also cruelty.
Lordship, why?
No, your Lord,
why I'm
but
submitting,
there is
Lordship?
nothing on the record, your Lord.
Because, Lordship, why I'm submitting, Lordship? Because it was charge sheeted in the year, Lordship, 2024. Yes, 24. In the meantime, Lordship, maybe cognizance or maybe charges has been framed. We do not know, Lordship. So under what
No, charges not framed yet.
the cognizance has been taken, Lordship. So that has to be before your Lordship. Under what section it has been cognizance has been taken?
No, your Lordship, it is still 85 is there.
And Lordship, he is already in bail.
No, your lordship, my bail has been cancelled, your lordship, its order is there, your lordship, at page number 37. Your lordship, I was on anticipatory bail, interim bail earlier, but later on 10/1/2025, learned APP has submitted before this court that the FR has been submitted. That is at para number 5, your lordship, may kindly be perused. Page number 37, para number 5. And on that ground, my anticipatory bail has been infructuous, your lordship.
So why don't you apply for bail again in the trial court?
Your lordship, for the time being, the interim may be given to me because
No,
on the
see,
next week, the date is there.
No, this case, it will become technically, legally and technically, this case will suffer. Why I'm saying if I stay without bail, then you will be deemed bail. You will be on deemed bail. If I stay
Your
without
lordship,
bail.
but nothing has been come out from the charge sheet or the FIR.
Why don't you apply for bail? Maybe there's nothing about cruelty.
Yes.
So cruelty is defined, new definition of cruelty is also there.
Yes, your
So
lordship. That is
let's-
why I am submitting, your lordship.
No, but you see, then you apply for bail also. It will take up both the matters together. This is not proper way of taking this interim stay, granting interim stay. You see, when I grant interim stay in this case, then it will be like nudging the court. You allow this person to go on bail, isn't it? Indirectly nudging the lower court that you allow this person to go on bail.
Yes, your lordship. But your lordship,
People-
I have been given impression that FR has been filed.
Yes, that's why you are. I think you are entitled to bail.
Yes.
You apply for bail before the trial court.
So, necessary directions may be given.
No, in this case, I cannot give directions.
Oh.
See, I am unable to even grant interim stay also because we have not applied for bail.
Oh.
You can apply for anticipatory bail also before the sessions court. You can apply for bail before the trial court, before the sessions court, anticipatory bail. And then if not granted, you come before this court, then we'll take both the cases together. But now at present, we'll issue notice only. I would have given you interim protection, but not
If I
in this
could have
manner.
been on interim protection, then there is nothing that I can contest everything. Your
No,
lordship.
no, no. In this manner, I cannot give you interim protection. Had you been on bail, I could have granted you interim protection, not now.
But your lordship, the first order I have been granted, that is at page number 34.
I think there are merit in granting bail. That's why bail was granted initially. But now here you are not on bail, then you have not applied for bail, and now you are asking for interim stay. You see, it will be, I think, in a very haphazard manner, I think, be getting protection. He will not be on bail, but he will be on interim stay. The protection will be very
Your lordship,
haphazard.
my impression is that
protection has to
the
be-
ingredients should be there.
You see, I would like the protection has to be legal and valid, not in a haphazard manner in this way. Okay. It's for your benefit, I'm saying. Nobody will grant you interim stay in this manner. Not any other court will grant you interim stay in this manner.
So I just made
Even
a
though
point.
you are entitled to interim stay, you won't get interim stay in this manner. First, you apply for bail. Then it will come in a seriatim. You apply for bail. If rejected, you apply again. Then you come up to this court. Then we'll take up both this matter. Then we can stay also the proceedings, but not in this manner. It's very haphazard and cumbersome.
Your lordship may pass a reasonable order. That is only my.
No, reasonable order. I wanted to pass a reasonable order, but how can I pass a reasonable order in an unreasonable way? See?
Your lordship, I have just that as the impression.
Please notice, then you apply for bail in the lower courts. This is my advice to you. In the lower court, in maybe anticipate bail in the sessions court, and if not granted, maybe here. Here, meanwhile, I'll issue notice.
So the case is being fixed
Then
on
we
the
also-
next one.
Another, I think I found another case of this nature, then they have preferred to apply for bail, and then both the cases will be brought together. Maybe they have preferred to apply for bail in this court because earlier bail was rejected, AB was rejected in the sessions court. So for criminal petition and the AB will be brought together.
Your Lordship, first I have been given an impression that no, your case is being FR. Then that is why I have not applied for the bail here. Because otherwise I could have gone.
No,
because-
but now that you know that charge sheet has been submitted.
Yes, Your Lordship.
Well,
Because the case is very, next date is very near to me. That is why.
then I'll give you a short date. I'll give you a short date. But notice will not come in a short date.
Yes,
This
yes.
case is from which place? Gwalpara or something like
No, no, not Palpara. It's a Gauhati Fatasili.
Patasi.
Yes.
Okay, then I'll give you a short date, but I don't think notice will be returned within a short date. Learned Counsel, Mr.
M. Sharma, Your Lordship.
M. Sharma is present for the petitioner. And Learned Additional PP, Mr. B. Sharma is present for the respondent state, full stop. Issue notice to the respondent, stroke complainant, returnable within 2 weeks. Or you want a date?
Next date is on Wednesday, Your Lordship.
Okay, on Wednesday, but it won't come, notice won't it be returned. Meanwhile, call for the Wednesday date to be, meanwhile, call for the scanned copies of the trial court records along with the scanned copies of the CD. List on 6/5, returnable on 6/5.
Hello.
You see, if you apply for bail, then you may get interim protection.
And Your Lordship, the question of the interim may be open, Your Lordship.
No, nobody will give you interim protection.
No, no, I am not seeking.
When you're not applying for bail, nobody will give you interim protection.
Item 12.
This is a criminal petition seeking recall of the NBWA and proclamation attachment issued against the petitioner. Your Lordship, FIR and charge sheet was filed under section 420, 406 of IPC, and subsequently cognizance was taken against the petitioner and others. Accordingly, petitioner appeared before the trial court and he was allowed to remain on previous bail. But on 17/02/2025, the learned counsel, engaged counsel for the petitioner, failed to take steps, and therefore NBW was issued. And on the very next day, proclamation attachment is
1 year back.
Yes, Lordship. So next date is for appearance and report. Meanwhile, Lordship, the said engaged counsel in a different case pending before the same court also failed to take steps, and thereby we have filed a criminal petition, and this honorable court was pleased to release the petitioner on bail on appearance. So similar relief may be granted.
Yes. Can Steve?
Okay, only one.
Can be kept in abeyance.
Page 59, Lordship, can we see?
Page 59.
Yes.
Oh, PNA has been executed.
Yes.
Oh,
So he was in knowledge on 6/11/25. Lordship, the trial is at the stage of
Yes. 0206. Will be allowed to appear, Lordship. Is willing to compress.
you'll be allowed to appear, but PNA has been executed. That is a problem. What type of order to be passed? But he has not been declared and proclaimed offender, no? Last date?
Last date is. It can- Eight, 4/2026, Lordship, at page 63.
the FIR is of 2020. FIR is of 2020 and till date, Lordship,
8/4/2026, no? Who is the accused? What is his name?
Abhishek Bora, Lordship.
Charge sheet submission under which sections?
402 and
Huh?
420 of IPC. 406 and 420 of IPC.
For what? What is the allegation?
Criminal breach of trust and cheating and dishonesty.
Amount?
It was around 6 lakhs. But
Another
6 lakh 50.
another case is pending against him, and in the same case, in that case also, Lordship, PNA was issued, and subsequently he was allowed to
Yes, sir.
allowed to appear. The only thing, Lordship, because it is 420 and 406, I leave it to you, Lordship. Otherwise, his conduct is not good, Lordship.
What is your submission that the engaged counsel did not take steps?
Yes. It was
Which,
under the bona fide thing
which
that-
paragraph?
Page 8, para 11.
Okay then. Third miss.
P. Bora, Lordship.
P. Bora, learned counsel for the petitioner Abhijit Bora, who has filed his application under section 4. 528, read with section 442 of the BNSS 2023. We pray for setting aside the orders dated 17/2/2025 and subsequent orders dated including the last order dated 8/4/2026, passed by the learned judicial magistrate first class Golaghat, Assam, in PRC case number 157 of 2023, issuing NBWA and PNA against the petitioner. Please stop. The next date fixed for appearance is 2/6.
Yes, Lordship.
2/6/2026. Full stop. The learned additional PP, Mr. B. Sharma, has raised serious objection stating that has raised objection that the accused has an antecedent of a similar nature, has a criminal antecedent of a similar nature in connection with another case registered as. Can you give me the case number?
Lordship. CR case number 37/2023. The other case where he was granted bail. CR case number 37/2023.
CR case number 37/2023. 23. It is also submitted. Now it is also submitted. I have considered the submissions at the bar with circumspection. The learning counsel for the petitioner has submitted that he was under the bona fide belief that his engaged advocate had been taking necessary steps. And of course, he was not aware that NBWA and PNA has been issued against him. The last order was passed on 8/4/2026 in connection with PRC case number 157 of 2023 under section 406, 420.
420 and 406 of IPC.
For IPC relating to cheating relating to cheating for wrongful gain of rupees 6,50,000. I have considered the submission that the petitioner is willing to appear before the learned trial court and cooperate with the trial. Full stop. A pragmatic view is taken. Full stop. Further pendency to avoid further protection of the procrastination of the proceeding, the PNA and NBWA issued against the petitioner is kept in abeyance for 50 days. and within 50 days, the petitioner is directed to appear before the learned trial court and cooperate with the trial. In terms of the above observation, this application stands disposed of.
Item 30.
May I please, Your Lordship? An application under 526 BNS for quashing and setting aside the impound order number 9 February 2026. Huh?
PNA was issued.
Yes, sir.
Have you annexed the copies of the orders?
Yes, sir.
Let me see. Continuous.
12 to 15, page number. 12 to 15, order and 12.
12 to 15.
Hmm.
No. Orders of the court.
Yes. That are in 12, it is in 14, page number 14.
Annexure 5.
Annexure 2.
Not this order. Continuous orders. What is his name?
Yeah. Page number 20.
What is his name?
Deepak Kumar Singh. Your Lordship,
Wait. Let me read the orders. Wait. Yes, PP.
Lordship, he has not appeared. Lordship can consider his.
We'll keep it in abeyance. Let him appear and cooperate with the trial.
Only thing, Lordship, Lordship kindly come to page 30.
1313.
30. The co-accused Lordship, he was granted bail by the concerned court Lordship. Lordship will kindly see the middle portion. Lordship will see the accused is also directed to submit his ID proof, recent photo, phone number to the court. The accused has submitted his official ID card, so and so, Aadhaar card, passport photo. So it was given Lordship because they are resident of outside. So similar condition may be imposed on him. So
The court will give permission.
yes, so that he participated in that.
Just ask him to appear.
Yes.
This type of conditions are required, but
Yeah. Because they are resident of outside Assam.
yes.
That is there.
Third learner counsel, Mr.
Biswajit Sharma, B. Sharma,
B. Sharma, for the petitioner Deepak Kumar
Singh.
who has filed this application under section 528 of the BNSS 2023 with prayer for quashing and setting aside the impugned orders dated 9/2/2026 and 20/03/2026 and consequent orders passed there on by the Chief Judicial Magistrate Dima Hasa Haflong in PRC case number 144 of 2025-24 arising out of Haflong PS case number 47 of 2022. The petitioner is booked under section 120B to 420 of the IPC. Full stop. Heard Mr. B. Sharma, learned additional PP Assam, who has raised objection against the prayer for quashing and setting aside the aforementioned impugned orders. Full stop. The petitioner, learned counsel for the petitioner, has drawn the attention of this court to the Annexure 1 series and which reflects the orders dated 9/2/2026. Full stop. The order depicts that the several summonses have been issued to the petitioner for a year, and thereafter the court was pleased to issue NBWA full stop. On his absence on 20/03/2026, the petitioner the petitioner, the court passed an order issuing NBWA and PNA against the petitioner, full stop. The petitioner is willing to appear before the court and cooperate with the proceedings, full stop. I have taken a pragmatic view, full stop, as the petitioner is willing to appear before the trial court and cooperate with the proceedings, it is not another. The petitioner, the NBWA and PNA issued against the petitioner is kept in abeyance for 15 days, full stop. Within and full stop, no comma, and within these 15 days, the petitioner is directed to appear before the learned trial court and cooperate with the trial, full stop. In terms of the above observation, this application stands disposed of.
Item 4.
Lordship, an application under 528 and 482 of BNSS Lordship. Yes.
POCSO case, Lordship. POCSO case.
Will issue notice? Learned counsel, Miss
G-Deca.
C-Deca is present for the
G-Deca.
petitioner.
G-Deca.
G-Deca is present for the petitioner. And learned additional PP, Mr. B. Sharma is present for the respondent state. Full stop. The learned additional PP has accepted notice on behalf of the respondent number 1, and thus no further notice is required to be issued. Issue notice to the petitioner to take steps to issue notice to the respondent number 2 returnable on 2 weeks or data. Meanwhile, it is under investigation or Sasi
Is submitted, Lordship.
Meanwhile, call for the scan copies of the trial court records along with the scan copies of the CDs. Of list on
19th May. Item 48, supplementary list.
May I please, your
yes,
lordship?
yes.
Lordship, in the present case, your lordship, by way of the present petition, we have challenged the order at page 22, your lordship. By this order, your lordship, the honorable court, your lordship, trial court, your lordship, rejected our petition, your lordship, under rejected our petition, whereby we have prayed for, your lordship, recalling the PW1, your lordship. Now,
This is pending at which stage?
at this stage of the for the supply of defense witness, your lord. Name of the defense witness. Now, your lordship may kindly come to page 22, your lordship. The issue is, your lordship, that very simple, your lordship. The charge initially was framed at 354 and section 10 of POCSO. Now, your lordship, during the 313 statement, your lordship, the honorable court was pleased to, your lordship, alter the charge to 354A. And when 350 charge was framed under 354A, we prayed for before the learned trial court that we may be allowed to cross-examine the not on all points here. Certain points we have mentioned in our petition itself, that since it was the charge has been altered, it is the principle of natural justice calls for that we be given a chance to.
Is the petition here?
Lordship, yes, I have annexed the petition.
Rejected petition?
Rejected petition. Your lordship will kindly come to page 18. That is the rejected petition, your lord.
Okay.
Lord.
Okay.
Now, your lordship, this is the
please,
settled
these are the grounds why the charge was not.
lordship.
Petition was rejected.
Lordship, I have carefully gone through the cross-examination of PW1 victim 1. I have also gone through the ingredients of section 354 IPC. On so and so, this court has altered the charge from section 354 IPC to section 354 IPC. Upon perusing the cross-examination of the victim again today, the court finds that victim has been exclusively cross-examination by defense, which is sufficient under section 354A IPC also. Hence, there is no requirement of re-examining the victim, and after altering the charge under section 354 IPC,
Moreover, re-examining the victim or any other witness will cause delay or trial or disposal of the case. Hence, this court finds that petition number so and so is devoid of any merit and prayer for recalling the victim for cross-examination is rejected. But your lordship, the fact remains that your lordship, this delay in trial cannot be a ground, your lordship, to reject my petition, your lordship. If I am entitled to, and your lordship may kindly see one judgment I am relying on this, your lordship, of the Honorable Apex Court, your lordship. This is not reported judgment. This was your lordship.
Paragraph number 21.
Paragraph number 21.
Paragraph what?
21, your lordship. Fourth line onwards. 1, 2, 3, 4th. A
Okay.
court may alter or add to any charge before the judgment is pronounced, but when charges are altered, opportunity must be given under section 217 of CRPC, both to the prosecution and defense, to recall or re-examine the witnesses in reference to such altered charge. This is my right, your lordship. Learned trial court cannot presume that you have exhausted everything. And
We
ingredients
have
of
given two elements. Two elements, I think.
one, your lordship.
Okay, one. Paragraph 21.
21. Fourth line onwards, your lords. A court may alter or add to any charge before the judgment is pronounced, but when charges are altered, opportunity must be given under section 217 of the CRPC, both to the prosecution and the defense, to recall or re-examine the witnesses in reference to such altered charge. This is what, your lordship, it is based on principle of natural justice, your lords. 354 and ingredients of 354A is completely different, your lordship.
All right, then, Mr. Sharma. Can we send to examine
Yes.
according to the, according to the petition?
Yes.
Lordship,
Not more than that.
lordship.
Only-
We are on the point
Yes,
on the
your lords,
petition.
lords.
Only thing, Lordship, the examination will be done within a period of time, Lordship. They
Yes.
cannot take adjournment on that ground, Lordship. That may be reflected, Lordship.
Please remind me. Where is the petition at page?
Your lordship will page 18, your lords.
Okay. Our learned counsel, senior counsel, no?
Lords.
Learned senior counsel, Mr. S. Bhutapur, assisted by learned counsel.
US Bora.
Huh?
US Bora.
US Bora.
Board.
Order. Postpone.
Foxo, your
You have to
lordship.
issue notice.
Lords, that is there.
Because I was about to
Lord.
pass an order.
Lords,
Can't help it, you'll have to issue notice.
lords. Normally, your lordship, so far as bail is concerned, it is required, but I don't.
In orders also,
Lord.
Wonderful.
before passing any order.
Lords,
Very sorry.
lords,
You can take it back
lords,
on a later date,
lords,
because defense evidence is also going on. I'll give you a short date.
lords.
It will likhila na. Issue notice to the respondent. Number 2, returnable on 2 weeks or date at a deduct 2 weeks date for 2
Lords.
weeks.
But feel, your lordship, then your lordship, this should be a stay, your lordship, the proceeding, because your lordship.
Cannot pass, I think.
No, your lordship will kindly see interim order, there cannot be any bar, your lordship. Final order, probably your lordship cannot pass without hearing.
Any order.
But your lordship will kindly see that once I disclose my
No, I
defense,
don't think so.
no,
And
once,
sir, let me see.
yes, your lordship can see, your lordship. Once your lordship,
Notification of start action, any order, I am sure.
lordship,
No, Pahari notification form. He will know about the notification. Wait, what is the notification number? I don't recall.
Asani notification form.
I'm sure it's any order.
Lordship. But the point is, your lordship, once I disclose my defense, it will be to my prejudice, your lordship. Defense witness, once we start taking defense witness.
Prejudice, you see, in the lower courts, whenever you are submitting that the case has been pending against this.
Your lordship
order,
can only observe one observation, your lordship, that we may be given liberty to file a petition before the seeking an adjournment.
Yes, sure.
That
Yes,
will do.
Issue notice to the respondent number 2 returnable on 2 weeks or date at a due. Meanwhile, call for the scanned copies of the trial court record along with the scanned copies not required actually,
Lordship, not required.
not required.
Only notice will be suffice.
Lada additional PP Mr. B. Sharma is present for the respondent state and has accepted notice on behalf of the respondent state, full stop. The petitioner is at liberty to pray for adjournment on the next date fixed.
Lords. Before the learned trial court.
Before the trial court on the next date fixed.
Deeply obliged.
Upgraded item 50 for orders.
Oh.
May please, Here, my lord. Order of this court, my lord, is at page 9, my lord. Here, my lord, POXO case number has been mentioned as 06 of the 2023. That should be, my lord, 37 of 2023, my lord. Page 9 is the order sheet, my lord, order. The POXO case number, it is reflected as, my lord, 06 of 2023, my lord. Page 9 and 10, my lord.
I can pass this order.
Lordship, my lord, because correction, only correction.
Huh?
Only for typographical error.
Court.
No, that court is also not available, and my lord, your lordship can pass an order, my lord, correcting this
As a
type
court is,
absence. Otherwise, also, my lord, because only my lord,
today it's closed,
that court is not available, my lord.
but it's trying other matters, no?
No, my lord.
Out of station.
Out of station.
Okay, out of station, then I can pass an order.
Lordship, I think it should be listed before the appropriate bench.
Yes,
No.
I before the appropriate court.
That bench is not.
To video
In the station.
conferencing, they can list it because to video conferencing, bail matters are taken up.
And this is for only for, my lord, correction of typographical error, my lord. That can be, my lord, any court, my lord.
Just the typographical error.
Any court, my lord. It is not a, my lord, review or, my lord, any order, my lord.
Can pass.
That's typographical error. It can pass, my lord.
I can pass, no? Typographical error, 362. No court can, 360, typographical error, 362, I don't know, 362 or 462.
That is in relation to judgment.
Judgment and order?
Yes.
Judgment and order.
Judgment and order, I think. 462 or 362?
362.
And similar section in BN-SS?
কিন্তু দেখুন আমাকে কি করবেন 362 আছে না প্রসিডিউরাল ওয়ান অফ দ্য কলেজ 403.
I think that court has to pass the order. I'm not sure. You come up in, he is saying that all the PPs are saying that I can pass the order.
Not sure, it's not a, my lord, judgment, my lord, only for, my lord, typographical error.
403.
403.
Court not to alter judgment.
Judgment or
Final order.
It's not final order.
disposing of a case shall alter or review the same except to correct a clerical or arithmetic error. Clerical error can be damaged.
Yes. I think that court will have to pass.
Except, my lord,
Final
clerical,
order, bail is a final order,
no, my lord, it's
not final order.
not final order, my lord.
It states also second part shall alter or review the same except
Clerical.
to correct a clerical or arithmetic error. So clerical and arithmetical error can be corrected first.
But that court will have to pass.
Yes.
No court where it has signed experience.
It's judgment and final order. That court will have to pass.
But it's my lord, not my
If
lord.
you see, supposing the district judge's court has passed the order,
Lordship, my lord.
then the next district judge can pass the order. But relating to High Court, I don't know, if the bench retires, then another bench will pass the order.
That's,
There are notifications of those nature. If the
But-
bench retires, the another bench will pass an order after retirement.
that is true.
But
my
if the bench is still sitting in says, if the bench is of a sitting judge,
lord. Not sure.
I think the judge will have to pass the order.
So far, my lord, clerical
Please,
mistakes
please,
are there, my lord. Earlier also, my lord,
It was
in such
always
situation, my lord.
my order was brought, I have never corrected other bench's order, never. My order may have been corrected by another bench, but this is the first time I'm getting. I have never corrected another bench's order.
And moreover, my lord, I am behind the bar, my lord. That's why there is some urgency, my lord. Otherwise, my lord, I'm in jail, my lord. That's why, my lord, some urgency, my lord. I'm behind the bar.
I understand.
Otherwise, my lord, it can be corrected, my lord.
There is a notification, that if the bench is sitting in another bench, then the bail matter can be taken up by.
In respect of bail, my lord,
Yeah,
this was
Christian.
lordship, my lord. In case of my lord, out of same police station case, my lord, that my lord.
If the bench is sitting out of station,
Then, my lord,
then
in respect
another
of same
bench will
police
take
station
up
case,
those
my lord.
matter.
May I suggest one thing? Lordship can seek a clarification from the registry itself, Lordship. If registry can issue a clarification to that effect, then Lordship can ask you if Lordship has any apprehension. Just a clarification from the registry. In case
To an order or
Lordship can do it.
to the courtmaster.
Yes, Lord to the courtmaster, and the matter can be taken up at this.
At two,
Yes, yes. Second half,
Second.
we'll get it clarified, second half.
Obliged.
He's sitting out of station. This bench
Lordship,
is sitting out of.
out of station.
Which station?
That station,
If he's
in-
sitting out of
but-
station, then I can take it up.
lordship, my lord.
I'm sure I can take it up, but I'll need the notification.
But-
I have forgotten the notification number. I have seen the notification. If bail matters
Lordship, my lord.
sitting out of station, then I can take it up. But I have forgotten the notification. Notification to lower lawyer any second half to clarify to lawyer any person. Don't worry,
Lordship, my lord.
I'll pass an order.
I'm obliged.
Item 15.
May I please your lordship, is an appeal against conviction matter. Under section 376D, 10 years manner.
10 years.
At this
okay.
stage only,
I'll admit it only.
manner.
Learned Counsel Mr. D. Bora is present for the appellant, who is aggrieved by the judgment and order dated 16/2/2026. Passed in section case number 119 of 2015. Convicting the appellant Horen Biswas under section 376D. 511 I
511.
to undergo rigorous imprisonment for 10 years and to pay a fine of 2,000 with default stipulation. Learned Counsel Mr. P.S. Local is present for the state of Assam and has accepted notice. And thus no formal notice is required to be issued. Post of however subsequent copies to be furnished during the course of the day. Issue notice to the respondent number 2, returnable within 4 weeks. Records from the trial courts. Admit this appeal. List accordingly.
That's it. We have done IA minor. Then the.
we will file objection also.
Learned people will file objection minor.
But for objection, we
Learned
need the
Counsel Mr. D. Bora is present for the appellant, so and so he is aggrieved by the judgment and order so and so in connection with so and so.
Okay.
Learned Additional PP Mr. P.S. Lofer is present on behalf of the respondent state and has accepted notice on behalf of the respondent. Full stop. It is submitted that the state will file an objection against the bail petition. Full stop. Against this application. Against this application. You want a date?
Any date minor in the month of
after receipt
May.
of the TCR also, because TCR will be required.
Okay. List this matter after receipt of trial
TCR.
court records.
Item 16.
19 to 20.
Anecdotes. Non-appeal. 16.
Petitioner is not represented today. Learned additional PP, Mr. P. Loker is present for the respondent stage. List after 1 week.
Please, sir.
My lord, there is a matter, my lord, I think number 19, my lord. That after that status report was called for, my lord, but you know, we don't have any instruction, my lord.
My lord, here, in the earlier occasion, my lord, up to date report was received, my lord. Lordship may kindly please for a moment, my lord. Up to date.
19, it will take only 1 minute, my lord. 19.
19. Okay, flag mark for us. Item 19.
Even we don't have any instruction, my lord, regarding this matter.
Lordship may kindly peruse, my lord, up to date report, my lord. It has written,
I think he
My lord?
press the matter.
my lord.
I think he is not willing to press the matter.
No, my lord, actually, status report was called for, my lord, the last date, my lord, 31st/10/2025, my lord. When the TCR was.
Lordship may kindly peruse TR, perhaps it has written as ST. Status report, that type,
Status report.
my lord.
My question is not.
Flag mark is there,
What I said,
Flag mark.
my lord. Next page, my lord.
yellow to me.
Here it is last person, my lord. Underline, my lord, here,
Pink flag mark.
my lord.
Pink or
Status-
yellow, my lord.
A.
No, my lord. Yellow, perhaps.
Yellow, I think my lord, yellow.
Yellow, my lord. Next page, my lord.
G. No. G is affidavit.
They have the paint.
Up to date status report of special NDPS has been received and the same is tagged at flag ST.
ST, my
On
lord.
record, okay.
My lord. Underline portion, my lord. Last portion, my lord.
Namely, Manik Singha and Ramjan Hussain and the same are allowed.
My lord. Bill petition
But
already
we-
allowed, my lord.
Yes, my lord, but we don't have any instruction. That's all.
So you want to continue?
Continue for a.
Well, let's give a short that, my lord, we'll take instruction from the client directly, my lord. Because
But from the state, status report reveals it.
He has become infractious.
maybe, my lord,
Huh?
because he was inside jail from 2022, my lord. Let's give a short that, my lord, the last question.
Because they have given affidavit that no bail application.
My lord, that is
Yes,
also.
yes, that's
Who
what.
has given affidavit and who has taken the advantage, nobody knows.
My lord.
Let's say that was on 2022 only. Before receiving TCR, my lord.
No,
Maybe.
2025, my lord.
No, here it was, arrest was 22.
Oh, arrested.
Who has given a false affidavit?
My lord, that is.
That
It is
is
to be found out. And
before
I'm
my-
not interested
So, my lord,
to
we'll take
find out,
instruction.
to rake up all these issues.
My lord, so we'll take instruction from the client, my lord, directly.
Then Council Mr. D. Bora has prayed for adjournment. Learned additional PP, Mr. B. Soman has submitted that status report has already been received, which reflects that the petitioners have already been enlarged on bail.
My lord, in the status report.
List this matter on.
Any that, my lord, we'll take instruction.
Learned Council Mr. D. Bora has submitted that he will obtain instructions.
Instruction from.
List this matter on when do you want? After 1 week.
After 1 week, my lord.
When? Date and a reading. 12. 12.
God bless you.
Fine. My